Okay, guys, why don't we get started and let's see where tonight, like I said, I'll talk a little bit more about logistics about the next few classes, assuming some more people make it in, despite Game 7 of the World Series. So let's see what happens. All right, so let's bring ourselves up to date on where we are and what we're doing today and what the next few classes has in store. So when you look at the index, hopefully with a bit more comfort these days, we have Chapter 1. We have entities subject to tax. We know what is an estate, what is a trust. Chapter 2, just explaining the fundamentals of how subchapter J operates and the small tweaks between a trust and estate versus individual taxpayers. Chapter 3, which we said was the defining moment regarding trust and estates and this notion of a distribution deduction and computing D&I, right, for section 643, and distributions to beneficiaries and their corresponding taking it into income. We saw this reflected in code sections 651, 652, 661, 662. We saw it with respect to complex trust and estates, Tier 1, Tier 2 distributions, that Tier 1 gets priority when it comes to D&I. Tier 2 gets whatever's left. We also talked about how specific requests under code section 663, right, akin to what you picked up hopefully in your income tax course under 102A, does not get picked up in income. We talked about trusts and estates, their termination, right, and we talked about the implications spelled out in code section 642H, right, and how for the first time, as opposed to during the life cycle of a trust and estate, losses are often, or not at all, distributed. But under code section 642H, losses and capital losses and administration expenses and the like in that final year can be distributed out to the beneficiaries. We talked too, and this is I want to remind people the importance of this, that when it comes to making distributions and the pulling out of D&I, Tina, do we look at the fair market value or the adjusted basis of those assets? And Anthony, see if you agree. They're whispering. I think it's the Anthony?
I'm getting mixed up with my corporate files. I think it's the adjusted basis.
Well, usually, just by, and that's not a bad segue, for corporations, remember code section 311 would trigger, you're not responsible for this, but just no one in this room ever wants to forget code section 311. Code section 311 triggers gains but not losses, right, on the distribution. If it's a corporate liquidation, code section 336, right, triggers gains and losses, except if special rules under 336D put brakes on allowable losses. You guys remember this from corporate tax? So wholly different than trust and estates, right? Because, CJ, you wouldn't be confused by this. What is the operative here when you pull out distributions of property, not cash? Property, do you look at the adjusted basis or fair market value?
Is that the lesser of?
The two?
Right.
And if so, what's your authority?
643E1.
643 deals with D&I, right? So, what code section were we on? No, I'm sorry. 643. I'm sorry. Deals with D&I, but 643E1, right, talks about the basis. 643 E2 talks about the amount of distribution, and you're right, it's the lesser of the two, 643 E2, right? And the basis here is spelled out in Code Section 643 D, E1, E1. 643 E1. And I said, this is good to you guys, for you guys to know these code sections right here, because these come up often in practice, and there's many accountants don't get this correctly. And Anthony, I just can't resist because it's in my nature. But if you looked at code section 301B, I believe, when you make a distribution out of property in the hands of the beneficiary, I just want to check myself. Under 301D, the basis is fair market value. Okay. There's a problem. And I believe,
Page 283.
say it again?
Page 283.
280, 283, what, oh, yes, page 283, yes. And then, I think you guys know by now, if you don't, you shouldn't be surprised, that I have a fixation when it comes to basis, okay? So my brain just, I've been writing a lot of articles, if you couldn't tell. So section 334, Anthony, deals with basis on liquidation of a corporation. See, basis is the kind of topic that for years, in my own opinion, was ignored in a lot of classes. And to me, it's like one of the things that people shouldn't ignore. There should be more focus on it. And this, if I didn't share with you guys, I'm working on a new paper. What's it about? I know no one's going to be surprised to hear it's about tax basis and why. Most of you are familiar with Code Section 1014, right? Basis equal to fair market value on debt. And you're also probably familiar with Code Section, right, Tina? For gifts, it's a carryover basis, right? 1015, right? And most of you know that, or maybe you do or don't know that, probably the third largest tax expenditure on the budget of things that are considered loopholes, mortgage interest deduction, it shouldn't be deductible, okay, theoretically. Employer-provided health care insurance, probably the biggest, should be taxable, right? It constitutes an accretion to wealth. But basis equal to fair market value costs the country billions of dollars every year. And twice in our country's history, in 1976, and then again in the year 2010, the country tried to institute a carryover basis rule, where upon death, instead of getting a basis equal to fair market value, there would be a carryover basis. And this new paper I'm working on talks about how to come up with a logistically feasible carryover basis rule. So once again, my brain is going there. Anthony, you're going to say?
What do you think, and I think you can finish, what do you think the reasoning is that the fair market value, the basis sets up the fair market value at that?
What's your question?
Like, what do you think the reasoning is behind it?
You really want to know?
Yeah.
I'm glad you asked. And I didn't even plan Anthony there. It was more or less an administrative error committed in 1921. Okay? Picture, if you will, the code is coming into being in 1913, right? When I say the code, the predecessor, the Congress, the 16th Amendment is passed. In 1913, we get our first income tax, right? And this is silent. The tax statute is silent. And for whatever reason, whoever's crafting the Treasury regulations back in 1921 says, you know what? In 1916, the estate tax is instituted. So there was this notion that that was one tax, and gee, there shouldn't be, even though they're wholly separate, there shouldn't be a separate tax. And also, bear in mind that the income tax was not created in a vacuum. That the United Kingdom, for many decades before, had an income tax. And in England, capital gains were not considered income until 1960, until the 60s. And remember, the U.S. is going to borrow heavily from those concepts of what is income. In fact, some of the income tax cases you looked at, there were some questions whether or not capital gains even constituted income. But indirectly, that led to maybe a psychology that whoever was writing these regulations, unchecked, came up with the same basis as equal to fair market value. I can send you an article, not mine, recently written about the origins of this. And it's not clear who crafted that regulation, but they probably had the mindset from someone from Great Britain. The then the then Secretary of the Treasury was adamant that these gains shouldn't be taxed because they were already subject to estate tax. So that dual psychology of the United Kingdom and the estate tax probably led to this administrative error in 1921. And I'll add, even though this isn't the reason, okay, so I'm about to say something that no one, because this is just me and my brain, is that back in the 1913s, and when the code is first coming into existence, it was, let's face it, do people know the tax basis of all their assets? And the answer is, in many instances, no. But in the 21st century, and I think you guys know I played a role in getting, for example, marketable securities. Most people now know the basis they have in their marketable securities because brokerage firms have to track it, okay? And that's a large part of appreciated assets. So my point is 100 years ago, this probably would have been hard administratively to come up with a viable carryover basis rule. And part of the article I'm writing now is, hey, 2016 and going forward, we could probably, for most assets, come up with a viable carryover basis rule. That's, by the way, in 1976, Congress enacted a carryover basis rule at that, and the bankers and everyone went crazy saying this is just never going to be able to be administered. It was put on hold in 1978 and then retroactively repealed in 1980. So it started and it got held back and then retroactively repealed. Okay, so anyway, you never knew someone could get so excited about tax basis, right, guys? So we spoke about these issues, and again, in fairness to you, on the final exam, it's a cumulative exam. These are the kind of things that, obviously, can you do what we did on the midterm? Can you compute D&I? Can you compute an income distribution deduction? Can you compute, again, very similar kind of, I hope you agree, straightforward problems, nothing, no curves, nothing like that. And then, added to that, can you, what is 663? What is 642? What is 642H? 643E, 642H, can you put those things into action? In addition, we're going to be looking at Grantor Trust, right? So can you identify what is a Grantor Trust, right? So that's going to be part of the exam, identification of what is a Grantor Trust. And then the last two classes, and we'll talk more about this towards the end of today's class, we'll be dealing with charitable trust and IRD, new acronym, right? So income with respect to decedent, code section 691, right? So that sort of gives you 30,000 feet up what we can anticipate. Okay. Questions themselves are going to be fairly generic. People know I calibrate my winter break based on how well you do. So you guys will determine my fate. If you do well, it will be a good winter break, but if you don't do that well, I'll take it as a reflection that I didn't do my job here. So I'm hoping you guys will all excel so that your time on Wednesday nights were well worth it. All right? You know your mission. You guys, any questions, logistically or otherwise?
Is the final on the 7th of December?
It is. Now, I know back in August, many of you were not happy campers. Before Memorial Day, not Memorial Day, Labor Day, right? Like, who has class before Labor Day? But now that we did that, guys, here we are. Your winter break will start early, all right? So that also means, though, be forewarned, CJ, that also means your Thanksgiving may be a super Thanksgiving because you'll have to look at tax, all right? Everyone good? All right. So let's just talk a bit about Grantor Trust, which we said there's a particular part of the code that's dedicated to Grantor Trust status. And that begins on Code Section 671. And 671 talks in general about the consequences of being the Grantor Trust. 672 sets forth definitions, which we looked at. Remember, the authors start this whole thing with this assignment of income, looking at some of the famous cases, because remember these famous cases set sort of the flavor of what the Grantor Trust status is all about. These assignment of income cases essentially say, if you have enough control over property, even if you don't touch the property, it's still subject to tax in your hands, right? So if you recall, Lucas Bureau, you performed services and you had the right, but you gave that right to someone else, that you're still taxable on it. And similarly, with respect to interest coupons on covering being forced, that if you control the realization and you hand out those interest coupons, your control of that will make you taxable. So we went through that, and then we did look at Helvering v. Clifford, famous case where if you have enough indicia of ownership over a trust, the trust will be ignored. And that gave way to the famous Clifford Trust, right? And people avail themselves of Clifford Trust, any trust beyond 10 years and 1 day, or beyond 10 years, was sufficient to constitute a standalone entity. Taxpayers could avail themselves of the lower tax rates. All right, and then we looked at the definitions, and then under Code Section 673, we began reversionary interest, which markedly changed, right, since 1986. It used to be if the reversionary interest didn't kick in for 10 years, it was sort of not considered a Grantor Trust, a non-Grantor Trust. However, that law has been subsequently changed so that if it's at least if the reversionary interest exceeds 5%, then that's going to be considered. If you look at 673A, the grantor should be treated as owner of any portion of a trust which has a reversionary interest where essentially the actuarial value exceeds 5%, right? And when you began looking at the problems, right, on page 266, and we saw in prompt 4-1, we have a 1985 trust. That wouldn't have been, and again, you're not going to see any history on the exam, but because this trust didn't exceed 10 years in prompt 4-1, that it was considered a grantor trust, even back in 1985. In prompt 4-2, since it exceeded 10 years, it was going to not be considered a grantor trust. However, I did point out in problem 4-2, because there is a reversionary interest as to principal under Code Section 677A2, it would be a grantor trust as to principal, right? Because that amount would inure ultimately to the grantor. 4-3, we just pointed out back in the day that back before 1986, that you could ignore people's ages. You could ignore the ages of the beneficiaries. Again, meaningless today. You're not going to see any questions on that. 4-4, this year, 2016. We have a grantor creating an inter vivos trust. All the income is to be paid to grantor's sister for 10 years and 30 days after the trust is to terminate, and the principal is to be paid to the grantor. Does that work? What do we say in your notes? Didn't work, right? Because what table do we go to? If you go to your code, hopefully everyone can find it, 2031-7B6. And DISA, if you have the same code as I do, is page 13, it's page 1613. Does everyone have that? Let's see that. You find it? Regulation 2031-7D. 2031-7D. Table B. What year code are you using, Rashida? Wait. Yeah, but are you using this year? So just go to page 1613. Got it? You see a table there? I don't, what, do you have 2016 or 2017 on the outside? Anyone else using 2016?
I am.
Wait, but that's a different book that I think she's using.
Yeah.
This is West. Did you find it? Can you just give her a hand? (2031-7D) Table B. Is it there? Table B? Because we have to, there's different tables. Okay. So, if you look, term of 10 years. You see term of 10 years? If the interest rate is 5%, what's the value of the remainder interest? Jenny? Yeah, 61.39%, right? So that's not less than 5% last I checked, right? Everyone agree? And you see, the longer the term of years, the smaller the remainder interest is. Agreed? So if you turn the page, if you go out to 57 years, and you go to 5.4%, so it's got to be 57 years, and if the interest rate happens to be 5.4%, Adrian, the remainder interest there is what? If I'm not mistaken, it's 0.049898. See that? Did you see that? Adrian, you got it?
I don't have that table.
What?
I don't have that table. I don't know why I cannot find it.
It's not in your, it may not be.
I don't think it is. I mean, it didn't mean for it. 131.
Fine. No, you're not gonna have this again. Right. You can Google it though. Just put it in. 2031-7D. It should come up with all of this. All right, everyone see that? Just, I mean, the point making is that, and by the way, we're in such a low interest rate environment that the trust might, in this age environment, might have to go out 100 years to have a 5%, less than a 5% remainder interest. All right, so everybody see that?
I assume you'd give us a rate for exam problems?
I give you a rate, I would probably tell you. I mean,
Okay.
This does not come up much in practice. I'll tell you why. And you're not going to have this in your code book. But if you have a reversionary interest in a trust, guess what happens? No one's going to fall off their chair. Under the estate tax laws, I believe it's under 20. Hey, can you Google code section 2037? I believe, I just don't know for sure, 100% sure what code section. What's it entitled?
Transfer staking effect of debt.
I have to check the language of that. But there's a code section, I know for sure, chapter 11 of the Internal Revenue Code. It's 2030, I think it's 2030, if you kept reading that it comes back into your state if you have a reversionary interest. So why do people set up trusts? To protect their beneficiaries, everybody agree? And why else do they do? To minimize tax, combination plan, right? Having said that, why, think to yourself, you're setting up a trust. Are there many of you in this room who would really want a reversionary interest? When I say to clients, hey, you're considering setting up a trust, I say to them, don't anticipate ever seeing this money again. Even if you think you have a friendly trustee, who knows in life? You know, they have fiduciary duties to keep it to the children, never back to you. So my point is, would you ever say, visualize setting up a trust for yourself, if you have children, where it would revert back to you at the end of 10 years, 20 years, or 30 years? Why do people have these reversionary interests? They did it simply so they could park the money, right? And try to save the income tax during the 10 years in one day, right? Everyone agree? That was the whole objective here. The reversion, this wasn't being done for estate tax purposes, right? No estate tax purposes. And was it really done to protect their children from themselves long term? No. It was done purely as a tax savings vehicle. Having said that, in the year 2016 and going forward, knowing that you can't do it unless the reversionary interest is less than 5%, and even then, we know that trusts, right, aren't they taxed, the income tax at the highest rate under Code Section 180? So is anyone going to do this to save taxes? So, do you think many people have reversionary interest in their documents? The fact it's malpractice if you don't, as an attorney, put in a provision that says under no circumstances shall I have a reversionary interest in this property. Because otherwise you're going to cause estate tax inclusion. All right. So, question 4-6. This year, G creates an inter vivos trust. All the income is to be paid to child, minor child. Upon C's death, the trust is to terminate. If C dies prior to attaining age 21, the principal is to be paid to the grantor of living, otherwise to the child's estate. The 673 treat the grantor as owning any portion of the trust. And what do you notice about 673?
Excludes, it doesn't count, does it? Doesn't count as a reversionary interest.
It doesn't count, why? Because code section 673B. Says, in the case of any beneficiaries who is a lineal descendant, which that is, the child is, and holds all the present interest in any portion of the trust, the grantor shall not be treated under subsection A as the owner of such a portion solely by reason of reversionary interest in such a portion which takes effect upon the death of such beneficiary before the beneficiary attains age 21. Right? So that would constitute an exception. It would not be considered a grantor trust. However, I will point out, until the child turns 21, the grantor is considered as having a reversionary interest. So any capital gains under 677A2, that's the code section we looked at before, that was earned, since he retains a reversionary interest during that period, those would be taxable. So on the income, not a grantor trust. As to principal, grantor trust until the until the child attains age 21. Question 4-7. This year, grantor creates an inter vivos trust. All the income is to be paid to child for child's life. Upon child's death, the trust is to terminate, and the principal is to be paid to grantor. Okay? Again, strange, right? Who would ever set up this kind of trust? Normally, it would go to the grandchildren, right? And that would be what we would call a generation skipping transfer trust, right? Normally. But that's, the authors are having fun here. C was 2 years old at the time the trust was created. The 673G treat the grantor as owner of any portion of the trust. So presumably the IRS is going to use actuarial tables, right? And here they do so. If you can turn again, and Adrian, I know you can, but if you were to Google 31-7D, Table S. Table S. Hopefully that pulls it up. And you see a 2-year-old. Would this work in the year 2016? Anthony, you're shaking your head.
No, because interest rates are so low.
Yeah. The so-called code section 7520 rate is so low that at 4.2%, the remainder interest is 5.8%, right? So only if interest rates, and I know, what is it, Janet Yellen might raise interest rates, but it's still, it won't cause us to go too high. and interest rates were at 4.6%, right? At 4.6%. The actual value would be less than 5%, right? Everyone see that? Daisy, you got that? Jenny, you got it? All right. I mean, I don't know why. I like looking at these tables. You can sort of measure where you guys are on the life cycle and see how every year you have a birthday, remainder interest is getting larger and larger for you and me both, right? All right, so your answer for your notes, it would really, the last question here, and Patrick, we're looking at 4-7. The answer would depend on what the interest rates were.
And that only applies to the principal, that actually will revert.
Yeah, it would only apply to the, how do I say this? If the actual rate exceeds 5%, that is taxable on income and principal. If the actual rate is less than 5%, he's still going to remain taxable on the principal, code section 677A2. Right? Everyone agree? That even in this problem, we know no matter what, he's going to be taxable because he has a reversionary interest on the principal, on any capital gains. What's my authority? Code section 677A2. Go ahead, Anthony.
How does that change if interest rates are changing so much? Like on a year-to-year basis?
No, it's the year it happens. You make your evaluation at the date of contribution.
Okay.
Right, you ready to look at code section 674? That's what the authors are going to do. We're going to go through each code section under the Grantor Trust rules and hopefully be able to identify those that I would say we have Grantor Trust. And 673, let me just in closing say, in my opinion, this rarely, virtually never comes up in practice. If it comes up, in my opinion, someone made a really bad mistake, okay? That most, I have to say, guys, I don't think I can recall, I started practice after Clifford Trust went out of existence, so I've never seen anyone purposely put a reversionary interest in a trust, ever. But sometimes, let's face it, guys, what happens in today's day and age? I've seen people worth big money and they say, oh, who needs an attorney? I'll just pull off a document off the internet. And who knows what they might pull off and what powers may lurk there. So just be careful, all right? Don't think 673 is dead forever. Bill?
Is it still ever used for the minor children thing? Or
Okay.
is it still ever used for the minor children thing, or it's not?
I never see it used, ever. Okay? 674, beneficial interest. Okay? Remember, Congress has said if you can control money, right? You can control money, you should be taxing the money, right? The theory being that even if you don't touch it, your ability to have the puppet strings is tantamount to taxability. Gives Congress license to tax. So the general rule is pretty broad. Oh my God. The grantor shall be treated as the owner of any portion of a trust in respect to which beneficial enjoyment of the corpus or the income therefrom is subject to a power of disposition exercisable by the grantor or non-adverse party or both without the approval or consent of any adverse party. If you read that alone, virtually every trust created would make it, the income earned on that trust would be considered grantor trust, right? Because essentially says, if you can control beneficial enjoyment of the corpus or income, and that power is held by the grantor or non-adverse party, that's going to make a grantor trust. Do you see the breadth of that, guys? Virtually every trust ever created would be a grantor trust under Code Section 674A. The only time it wouldn't be is if an adverse party, you needed the approval or consent of an adverse party. Let me just make another observation for you. How many times do you think I would see or you would see where you would put someone who has a beneficial interest, give them veto power over the grantor or the non-adverse party of some sort? And let me just answer that question. You'll never see that, okay? You'll never give those kind of powers to a beneficiary to sort of trump what a trustee is doing. Okay, so if you just stop reading at Code Section 674A, virtually every trust ever created is a grantor trust. So, your next question might be, all right, that means that the exceptions probably are larger than the rule itself, right? And you've seen code sections like this that start off really broad, but because the exceptions are so broad, they really narrow the application of what you might think is the general rule. So what are these exceptions? Well, let's look at them. They come in three flavors. 674, B, C, and D. B, C, and D. Subsection A shall not apply to the following powers regardless of by whom held. So if you hold these powers, it doesn't matter who holds them, they're not going to be considered giving you the ability to dictate beneficial enjoyment. So if you hold any of the foregoing powers which are listed here, this will not trigger beneficial enjoyment. Okay? A power to apply income to the support of a dependent, if it's not utilized, we'll see. Power affecting enjoyment only in the occurrence of events. Only if it's testamentary, it's not considered a power. Power to allocate among charitable beneficiaries is not considered broad enough power to give you a indicia of ownership. A power to distribute corpus, which is limited by what's called an ascertainable standard or reasonably definite standard, doesn't give you beneficial enjoyment. Let me pause for a moment because you might get lost in what I'm saying. So let me give you an example. Suppose I set up a trust and Zhao, I name you as trustee, and I give you the power to distribute to my children, but you can only distribute to them based on their health, education, it's called a HEM standard. Health, education, maintenance, and support. That's considered a so-called ascertainable standard. So I give Zhao this power over this trust, and I put $1 million in the trust. And because he doesn't have unbridled control, he can only distribute corpus in this limited fashion. It's not as if J. Solar is considered as if I've retained enough indicia to control beneficial enjoyment for my children, okay? Because it's out of my control now. It's in his control, and even though he's an independent trustee, he's dictated by this ascertainable standard. So I can't say, gee, Sal, my kid really wants to have a yacht. Can you take part of that $1 million and distribute? He said, no, that would violate the terms of the trust. I will not do that. That will be a dereliction of my duties. But if I gave him unbridled control, okay, at least under 670, where I said he can do whatever he wants with the money as long as it's used for my children, that would not fall within the scope of 674B, right? Because that's not limited by an ascertainable standard. And if I put in a power that I can control upon my demise, like I put $1 million into the trust, and Zhao is the trustee, and I say, upon my demise, I can control where that money goes. Like I set up the trust today for my children, but I retain the ability upon my demise, under the terms of my will, to direct it. That's pretty powerful. But it will not make it a grantor trust during my life because, right here, 674B3 says that's only on demise, right? So I really don't have control of that trust because, short of me committing suicide, I can't get access to what I want to do with that trust, right? Everyone agree? My hands are tied. So if you're, as the grantor, if your hands are really tied, and that's spelled out in 674B, right? These are all provisions which more or less limits my ability to control, okay? It will not be considered a grantor trust. 674C, and even if I'm the trustee, okay? So even if, forget about Zhao, excuse me, you're not going to be a trustee. I will set up this trust and I'll be my own trustee. Even if I'm my own trustee, but I'm limited by these 674B, right? It says, if you look at the prefacing language, 674B, it says regardless by whom held. Anyone, including the grantor, can hold these limited powers. And by holding these limited powers, it does not trigger enough control to warrant grantor trust status. Under 674C, these are powers that if held by an independent trustee, it's okay. And 674C is essentially, Zhao is unrelated to me. And if I give him carte blanche that he can distribute trust income or principal to my children as he sees fit, he wakes up one morning and decides my son deserves a yacht, I can't stop him. But is it a grantor trust? Not a grantor trust because he's independent, right? So I can give him unbridled control. And under those circumstances, right, I have severed my interest in that trust. He's independent. It's his discretion. And 674D, there's a power to allocate income if limited by a standard. Then it's not going to be taxable as a grantor trust, okay? The income is not going to be considered grantor trust status. Okay, as long as it says, if that power is vested by a trust or trustees, none of whom is the grantor or spouse, the grantor spouse. And we're going to go through problems where you can see each of these. Look, Code Section 674. Let's look from 30,000 feet up again, guys. Is if you can't control, you set up the trust. We're not talking about estates. Let's just make sure everyone understands. We're only talking about trust, grantor trust, right? And we're trying to see if the grantor, meaning me, if I'm the grantor, or your client, or you who's setting up a trust, we saw a few minutes ago that if you retain a reversionary interest, well, depending on the size of that reversionary interest, the trust may be ignored. It's going to be treated as a grantor trust. Now, if you can control beneficial enjoyment, essentially who's going to get what when, that too may trigger grantor trust status. But there are several big exceptions, okay, which are spelled out in 674B, C, and D, which the authors tried to illustrate. Let me read, just for your notes, remember, 674B are powers that can be held by anyone, including the grantor. 674B are powers that can be held by anyone, including the grantor. 674C are those powers that you can give that can be held by independent trustees. And 674D are those powers which can be exercised by a trustee who is not the grantor or the grantor's spouse. Not the grantor or the grantor's spouse. Okay, so you have three different exceptions, and those exceptions turn on who's in control and whether or not they will be applicable. So the authors, to try to give us a taste of these code sections, give us several cases. Or to try to illustrate code section 674, offer several cases. Let's look at the first one, Swanson. Okay. Here we have Caroline Swanson in 1950 transferred common stock to W. Clark Swanson. It's not made clear if they're married or not. I think they're married. There's nothing in the decision that says they're married, but I would imagine they're married. So the wife is transferring stock to the husband as trustee of an oral declaration for trust. This was not written originally. I don't know who does this, but it was an oral declaration of trust. And at the time, this stock had a fair, I'm just sharing this with you. The stock had a fair market value of $3,000. And why $3,000? Just so you know, in yesteryear, right now, you guys probably know that under Code Section 2503B, that's what's called the annual exclusion. That's how much you can transfer free without gift tax or paying or using up part of your lifetime exemption. For many, many years, that magic number was $3,000, okay? And it was raised to $10,000, but for many years, the exemption used to be $3,000. So it's not arbitrary why that $3,000 was used to. Okay? So here the husband was named as the trustee. A few years later, they got around to writing out the terms of the trust in 1955. And if you look at Article 11 on page 267, kind of strange. The trust instrument shall be subject to interpretation or amendment by the maker. But any interpretation or amendment shall not vest the maker any right to property, income, or corpus, except as in the relationship of trustee to the beneficiary hereof. Okay? And These were irrevocable, okay? And just make sure you understand, because sometimes people, the fact that a trust is irrevocable does not, some people are under the misimpression that sometimes if it's irrevocable, it's not, could it be a grantor trust? Many, many irrevocable trusts can be grantor trust. The fact that it's irrevocable does not mean it's not a grantor trust. So, here, just so you know, this power that was written out gave complete discretion to the trustee to make distributions as he saw fit. And the trustee also had authority to borrow money as he thought important. So look at page 268. The third paragraph. Section 11 of each of the three trusts is clear on its face. Each section provides the maker, that's Clark, had the right to interpret or amend the trust instrument, limited only in that he could not vest ownership in himself. If you go down two more sentences, this is key. With almost unlimited power to amend the trust, Clark presumably could add or change beneficiaries or alter the trust provisions that he can have complete control over the trust property. Does this mean he can control beneficial enjoyment? Pretty sure, guys. You can add beneficiaries at whim. And since how many people walk the face of the planet these days? How many billion? 7 billion? Okay. 7 billion minus 1 is still a big number. So if you have, you could give it to everyone but yourself. That's a pretty broad power, right? So, can he fit within the scope of section 674B, right? So this, remember, he's not an independent trustee under 674C, so that doesn't work. Under 674D, the grantor himself is the trustee. So if we're going to win, or he's going to win, it's got to be under 674B. And if you glance through these exceptions, none of them seem to apply. This is not limited by an ascertainable standard. Does this point out? Remember, the husband contributes some of these assets himself, and the wife contributed, assuming she is the wife, the other assets. So at the very last paragraph, you can only be a grantor trust as to those assets you contribute, right? I repeat, it only can be a grantor trust as to those assets you contribute. And here, it actually, there was 2 grantors to this trust.
That was my question. Can you have more than one grantor?
It's 2 grantors. In this case, de facto there were 2. The husband and wife were both. You can have 2 settlers to a trust. I've created where a husband and wife set up a survivorship insurance trust. So, just just to reiterate, we looked at 674A, which says it's a grantor trust. 674B, none of the exceptions there apply. And C and D on its face couldn't apply because the grantor was the trustee, so that negates 674C, negates 674D. Right? How about Goodwin? Not a hard case to follow. Anyone read this case? Have any thoughts? Here we have the prototype of the control freak, okay? Everyone in your life, someone in your life or multiple people you've met in your life fit this description, right? Where they, how do I say? They fit this description insofar as they theoretically want to give up control, but they can't give up control, right? You've met people like this? And here we have someone who's setting up a trust, right? In fact, he set up several trusts. The trustees were the librarian for the Supreme Court and another attorney, 2 people, independent trustees, right? But what happened here, so far as the management and administration of these trusts are concerned? Who ran the ship? Yeah, Mr. Goodwin. Okay? He made and he controlled and he orchestrated everything about these trusts. He made all the management decisions, distributions decisions. He would make out the checks and essentially say to the trustees to sign them. And the IRS would make the argument that, gee, he was a de facto trustee, and under Code Section 674, right, this should be considered a grantor trust. Everyone get the visual? And remember, the agenda pre-86 was simple. If you could have the trust be an independent taxpayer, the tax onus would be less than if the income would be taxable to the grantor. Right? So, who gets taxed on this? Because he did control every aspect of these trusts, right? That he set up. And the answer is, under the Clifford decision, we would have said taxable. But the Clifford decision has come and gone, right? Let's put it this way. If he didn't do all this, if he didn't do all the management, let's suppose for a moment he set up these trusts and he had independent trustees. Would the grantor trust rules apply? Adrian? Well, on the face, 674A might, but 674C since these are independent trustees, it would have worked, right? 674C, these are the kind of provisions and powers that an independent trustee can hold. It will not trigger a grantor trust status.
So a quick question about 694C. That's basically, what they list out there is essentially what any trustee would normally do in the normal course of administering a trust, right?
Right.
Okay, so it's just, as long as they're independent trustees.
As long as they're independent trustees, this can be covered.
Okay.
And the question is, the fact that he micromanaged everything, does that trigger Code Section 674C? And the court rules in favor of the taxpayer, okay? Remember, if you look at the last paragraph of the decision, Code Section, page 273, it says specifically, Section 671 precludes attributing the income to Goodwin on any theory of dominion and control under the definition of gross income, including the Clifford Doctrine. In other words, remember, Clifford is dead now, right? Code Section 671, right, guys, says with specificity that you don't apply the old Clifford rules. This is it. These are the only rules. And here, going back to page 271, if you go to the second last full paragraph, it says regarding the effect. Second to last paragraph, it says, additionally, it is clear that during the years, 3 lines down in that paragraph, additionally, it is clear that during the years in question, the trustees were not related or subordinated parties within the definition of 672C, whose discretionary power is to distribute or accumulate income to the beneficiaries would attribute the income to the grantor. Rather, the trustees were independent trustees within the meaning of 674C, who may have such a discretionary power over income. Why am I calling that to your attention? Because these 2 trustees were at fiduciary risk, that even if the grantor was doing all these things and something went awry, guess whose fault it is? The trustees. They could not just say, well, we granted deference. I mean, their neck is on the line. So at the end of the day, the court holds them accountable, and as such, they are truly the face of the trust, not the grantor. So the IRS is on thin ground, very thin ground, when the IRS argues on page 272, the second to last paragraph on that page, the second line down. It is respondent's argument, however, that although the grantor does not specifically have a power, his relationship to the trust through its management and administration of these trusts generally is such that he should be deemed a trustee, in fact, during his life. So the IRS was saying, well, de facto, he was the trustee, but he wasn't. So this doesn't work. Now, the authors do put it in the material that follows, that page 274, item 5, they point out that there's contrary law, that some courts have said, notwithstanding what this court said, under Goodwin, that they have taken a contrary position. So just be forewarned that there are courts out there that might look at askew at this. But I will stand by, I think this case is good law. Meaning, I think the taxpayer has a very strong argument that you can't look beyond the Grantor Trust rules and you can't try to read Clifford back into the law. So if you look at, again, on page 274, that there's some cases which the author cite to for contrary holding, but I think those cases are problematic. All right, you want to look at the problems here? Let's see if you guys know this. 4-8. Grantor creates inter-bios trust. The trustee is authorized to distribute such of the income of the grantor's sister as the trustee in its sole discretion sees fit. And upon the death of the sister, the trustee is to distribute the trust principal and any accumulated income to the sister's then living issue per stirpes. Per stirpes, again, just means by the root, so that if one of the sister's children dies prematurely, it would go to the grandchildren of that deceased child. Or it would go to that deceased child's children, which would be the sister's grandchildren. First National Bank is the trustee. This code section 674 treat the grantor as the owner of any portion of the trust. So again, we have each one of you creating a trust, picture if you will, for one of your siblings. Hopefully no one here is an only child, so I'm hoping you guys can relate to this. So you're setting up a trust for your sibling. The income is going to go to your sibling. Okay, so the trustee has discretion to make income distributions, and upon the demise of your sibling, trustee is to distribute trust principal and accumulated income to your siblings' children, your nieces and nephews. You need First National Bank. Is that a grantor trust? Yes or no? And why?
First National Bank's an independent trustee.
First National Bank, I hope, is an independent trustee.
If not, there's way more money involved in that.
If not, we're getting money under the table, but in theory, they should be an independent trustee. So, having said that, CJ, Oshida, is this a grantor trust? What's your, Oshida, what's your gut? Not a grantor trust. CJ, agree?
Agree.
And if you say not grantor trust, what's your authority? 674C, right?
Yep.
674A on its face suggests this is a grantor trust. Everyone agree? 674A, there's no powers held by an adverse party here, so 674A makes this seem like a grantor trust. But 674C says not so fast. If this discretionary power, and I think Dill mentioned, this is a prototype, right? This is, many times these kind of powers, sprinkling powers, right? Sprinkling powers, as they're known. To sprinkle the income, would say this is not a grantor trust. Right? And I think you guys get a visceral sense, right? Once each of you set up this trust, do you have much say in what happens here, guys? And even if you did, and it was like Goodwin, and First National Bank loved your business, so they said, Adrian, anything you want, we'll do it because we love your business, right? And again, I'm not trying to, in case you're, I don't want to sound, let's face it, Donald Trump had one of his banks, and assuming he didn't, it wasn't where he shortchanged them on one of his business dealings, you know, Trump probably could have a lot to say over the trust, right? And as long as, you know what I'm saying, like Goodwin, the bank probably would say, yeah, whatever you want, Mr. Trump, as long as you give us your business. But notwithstanding, it's still an independent trustee, right? Everyone agree? All right, so your answer, everyone agree, not a Grantor Trust. Let's mix it up. Question 4-9. Assume the same and the facts are the same, except that your spouse, okay? So whomever your spouse is in each one of you, okay? So we can relate this to you personally. So your spouse is the trustee. When your answer differ, the remainder beneficiary, okay, so the first part of the question is, what would be the answer if your spouse was a trustee? And then we'll get to the second part of the question. So think about it. And then we'll get to the second part. So if your spouse is the trustee, Tina, Grantor Trust or not? You better, so people can hear us. Say yes or no and loudly. It's a Grantor Trust. Why? Why do you say it's a Grantor Trust? Okay, you got to do better because the spouse is the trustee. You have a statutory reason? Say it loudly. 674D. What would make this a Grantor Trust? Well, can 674C apply? No, everybody agree? Because your spouse, last I checked, is not independent, right? Under the definitions under 672. And if you look at the last sentence of 674C, specifically says, for the periods which an individual is the spouse of the grantor, any reference in the subsections of the grantor shall be include a reference to such individual, treated as including such reference to such individual. Okay? Does 674D apply? No, right? Because this is not limited by a standard, right? Sole discretion. There's no standard here, right? How about 674B, which is a power held by any person? Okay? And this broad discretionary power does not fit within the scope of 674B, right? So, Tina, what code section applies? And I know you're thinking 674A, right? Making the Grantor Trust. Now, think for a second. Would your answer be different if the remainder beneficiary of the trust were your sibling's estate rather than your sister's children? Would your answer change? Now, where would you look to see if your answer changed? In B, C, or D? Where would you look, Tina? Say it loudly. D? C? That's not going to work because the spouse is not an independent trustee. So don't look at C. Would you look at B or D then? B, right? Not D because it's not limited by a standard, right? So you look at B. And you would have to see here, right, if we could fall within the scope, right? We're talking about income, right? Because the distribution is of income, right, to the sister. So let's power to withhold income temporarily, right? That's under B6. Everyone see that? B6. You see that? So a power to distribute or apply income to or for any current income beneficiary, or to accumulate the income for him, provided that any accumulated income must ultimately be payable to the beneficiary from whom distribution or application is withheld to his estate or to his appointees, provided that such beneficiary possesses a power of appointment which does not exclude the class of beneficiaries or appointees persons other than the beneficiary's estate or creditors of his estate. So let's go slowly. A power to distribute or apply income to or for any income beneficiary, or to accumulate the income from him. Provided, so that if you can pay out the income or accumulate it, you don't have a power that violates this provision, as long as any accumulated income must be payable to the beneficiary, okay, or to his estate. In other words, if your power is in this, your spouse is a trustee, and your spouse can pay the income currently, or it will vest to the estate of your sibling. That is not a tremendous power, right? Everyone agree? It's only a power to temporarily withhold the money. And that's not considered sufficient to give you indicia of ownership. I repeat, if you are setting up this trust and you name your sibling as the trustee, and you tell, your spouse is the trustee, I apologize. And it's a trust set up for the benefit of your sibling. And you say to your spouse, look, the only thing you can do here is to decide to distribute income currently to my sibling, or if you decide not to, it's going to vest upon his or her demise, meaning the sibling's demise. Does that feel like a tremendous control? And the answer, well, at least in the mind of Congress, it was not. And this would not be a grantor trust.
Certainly might disagree.
Some people might disagree with that, but at least in the mind of Congress. 4-10. Grantor creates an irrevocable trust, naming herself as trustee. Okay, so each one of you are going to role play here. You're going to set up a trust. You're going to name yourself as the trustee. The trustee is authorized to distribute income or principal, or both, to your adult child. So you guys started very young. Okay, so picture, if you will. You can distribute income or principal to your adult child in such amounts and at such a time as the trustee deemed necessary for the child's support, education, and health. Any accumulated income not paid to your child before death is payable to your child's estate. The trust terminates at your child's death, with the remainder passing to your grandchildren. The 674 treat you as the owner of any portion of the trust. Let's stop there. Think about it. And we can go through our process of elimination, right? What do we know doesn't apply? C and D, right? C doesn't apply because we don't have an independent trustee. Everyone agree?
Right.
D doesn't apply because it's discretionary, right? Hold on. One. Does D how do I say this? D doesn't apply because it says subsection A shall not apply to any power solely exercisable by a trustee or trustees, none of whom is the grantor or spouse living with the grantor. So D doesn't apply either in this context, right? So we're left with, right, Tina? We're left with 674A is making this a grantor trust, or 674B an exception. Agreed? Well, what about income in principle? Say again, Joe?
So which one is that?
674 with respect to income. 674B6A. We just learned that if it's payable, the income either to your child or your estate, the child's estate. That's not a big power, right?
Right.
And that would not trigger grantor trust status under 674B6A. Now what about B 674B5A? What about to corpus? Remember, you could have grantor trust status as to income. You could have grantor trust status as to principal, right? And because distributions here are limited by what's called an ascertainable standard, right? This standard, remember, is for the support, health, and education. That's a limited standard. So, under both of these standards, you would not have grantor trust status. Why? Let me summarize. Income will either be payable now or to the estate of the person, and we have an exception under B6. And corpus is limited by this ascertainable standard, and under B5, it will not be taxable, or it will not make it into a grantor trust. And if you look at the second part of the question, guys, it says, what if the accumulated income were added to principal each year and it was not distributable to A's estate? So now if the income is not distributable to A's estate and it will go to the grandchildren, so you set up this trust for your child and you can dictate whether or not it goes to your child or to your grandchildren. That's pretty powerful, right? So guess what? In that case, as to income, this would be considered a grantor trust as to income. Why? Because it would no longer qualify under B6 capital letter A, right? Because it's not payable to the estate. So your answer here for your notes, 4-10, not a grantor trust as to income or principal. In the first part of the question, as to the second part of the question, it's a grantor trust as to the income, right? Because it doesn't meet the requisites under 674B. It would be grantor trust as to the income under 674A. And as to corpus, it would be it would not be considered grantor trust and a separate 1041. Anytime you say it's not a grantor trust, what does that mean, guys? Essentially, if it's not a grantor trust, all the rules that we looked at for the last 10 weeks apply, right? You fill out a 1041 and report all that income on the 1041.
It's only for the income part.
No, you would report all the capital gains on the 1041. All the income would be reported on the grantor's income 1040, right? In that second part of the question. Remember, Code Section 671, and we'll see this next week, talks about the portion of the trust treated as a grantor trust, the portion. So a trust, some of it may be considered a grantor trust, the other portion may be considered a non-grantor trust, and chapters 1, 2, and 3 of our textbook deal with non-grantor trusts. And next week, we'll see some problems where we'll go through an actual illustration. Final question here, or at least for this segment. Grantor, again, role play here, this is each one of you, creates an irrevocable trust, naming her brother, naming your brother as a trustee. The trustee is authorized to distribute income or principal or both to any of the grantor's children in such shares and such amounts and at such times as the trustee deems appropriate for any purpose. Okay? So the trustee is authorized to distribute income or principal or both to the children in a broad discretion, right? Everyone agree? Very broad discretion. At the death of the last survivor of the grantor's children, the remaining trust assets pass to the grantor's then living descendants. Okay? The 674G treat G as the owner of any portion of the trust. So think about that for a moment. Think what might apply and what wouldn't. Now just call to your attention, is your brother considered, or your sibling, an independent trustee?
No.
What's your authority for that?
674C.
Well, that doesn't say who is and who isn't an independent trustee, right? 672C. Excuse me, 672C is entitled Related or Subordinate Party, and C2 includes your siblings, right? Everyone see that? 672C includes your siblings. So if they're an independent trustee, right, let's put it this way. Dylan, that knocks out the application of Code Section 674C. Everyone agree?
Yes.
674C cannot apply.
What is 674B5B?
674B5, capital letter B.
Yes, I don't know what that means.
Power to distribute corpus either to or for the current income beneficiary, provided that the distribution of corpus must be chargeable against a proportionate share of the corpus held in trust for the payment of income to the beneficiary as if the corpus constituted a separate trust. In other words, what this is saying, one second, I just want to make sure. In other words, if you have a power, this is under, Dill's asking about 674B5, capital letter B. Everyone have that open? And essentially what this is saying, and I don't know if I can paraphrase this correctly, that if you have trust for multiple people, and any time you make a distribution of corpus, that person is then gonna, like, you have 3 people who are the beneficiaries, and that person is gonna get the, a corpus distribution. But it's gonna be chargeable, meaning when that trust is actually distributed, ultimately, remember, it's one pot trust that ultimately is gonna be distributed to 3 people. It's gonna be akin to the so-called separate share rule, and it's
okay.
gonna be chargeable so that they're gonna feel the pain, and they will bear the onus of that. And if you notice the next sentence, which is key here, what the code is trying to say, or Congress is trying to say, is as long as your powers are fairly narrow here, and you can't add beneficiaries or give more wealth to another beneficiary. Remember, you had 3 beneficiaries, and if one person gets a distribution, right, isn't that akin to taking away money from the other 2? So if you give one distribution to this person, but that really counts against them and doesn't count against the other 2, that really is narrowing your ability to control beneficial enjoyment, right?
Okay. So it's that if you had $900,000 for 3 beneficiaries, you give number 1 $100,000, he's left with $200,000 of the
Exactly.
Got it. Okay.
All right, everyone here, Dill says you have a trust with $900,000 for 3 beneficiaries. They're supposed to share equally, and you give $100,000 to beneficiary A. When the trust is ultimately distributed, it shouldn't be that everyone now shares equally 1/3 of $800,000. Beneficiary A will be charged with that $100,000 and only get to keep $200,000. The beneficiary B and C will each retain their right to $300,000. All right. Question 4-11. We just took off the table, did we not? Code section 674C, right? Everyone agree? We took it off the table. We want to take 674D off the table.
No standard.
No standard. Everyone agree? We have no standard. So if we're going to win, meaning it's not going to be considered grantor trust status, we're going to have to win under 674B, right? And here, keep in mind, if you recall the fact pattern, we're authorized to distribute income or principal, but if we don't do it, whose hands does it end up in? It ends up in the remainder beneficiary's hands. Everyone agree? Meaning the grandchildren. That's pretty powerful, right? It doesn't get paid to the estate of my children. It gets paid to the grandchildren. So remember, in that context, 674B 5A and 674B 6A do not apply, right? They do not apply because those deal with temporary changes. This would be a permanent change, not temporary. So, is it a grantor trust?
Yes.
It is a grantor trust. What's my authority? Code section 674A, right? Grantor trust under code section 674A. Let's look at the second part of that question. What if the income and principal distributions were limited amounts that the trustee deems necessary for support, health, and education of G's children? So let's put it this way. Can I help you here? Does 674C apply?
No.
No. All right, everyone agree? Let's take it off the table. And we know 674B does not apply, right? Right? Because you can change beneficial ownership from the children to the grandchildren because it's not payable to the estate, right?
So that's just B6, right?
What's it? That's true. It's just B6, but B5. One second. say here, yeah, here, there's two ways I think you can get to the promised land. Under 4-11, we can look at 674 D, right? 674D. And there's an ascertainable standard. And then to Dill's point, you also get to the promised land as to corpus. Well, you get to the promised land to corpus under 674D, but it says, let me just remember, in the first part of the question, we have no ascertainable standard. Everyone agree? So 674B5A doesn't apply because there's no ascertainable standard. And because it's not payable to the estate, code section 674B6A does not apply, okay? So we're knocked out as to both income and corpus. And 674A applies. In the second part of the question, it talks about what if the income and principal were limited to an ascertainable standard, okay? In that particular question, we can have the application of 674D says the income is not going to be, under 674D, how do I say this? 674D, the income will not be considered grantor trust, right? We win. And under 674 B5A, because it's limited to ascertainable standard, the corpus will not get grantor trust status. Right? Let me repeat that for your notes. The second part of the question, we have to deal with both income and principal. And as to income, we're protected under code section 674D, not a grantor trust. And as to corpus, we have 674B5 capital letter A, because it's limited to an ascertainable standard. Where does this leave us? That means that the entirety of the trust income would be found under chapters 1, 2, and 3 of our textbook, right? And you just go through that whole mechanism that we, figuring out D&I and going through Schedule B and putting it all on the Form 1041. Questions? All right. Here's the game plan. Why don't we take our break now, and when we come back, guys, we'll go through code section 675, 676, and 677. And we'll talk a little bit about 678, okay? So why don't we take a